Good afternoon. We are now live, I believe, recording our regulatory workshop. My name is Patrick DeRay, Chief of the Bureau of Automotive Repair, and I want to welcome back members of the Bar Advisory Group who attended our advisory group meeting this morning, and also all interested parties who have joined us this afternoon for a workshop that we want to get some valuable feedback from all of our attendees today. And I want to first go over a few things. I want to first acknowledge our assistance that's being provided by our moderator, Ann Fisher with the Department of Consumer Affairs. And this meeting is being webcast. And I want to thank the support Mike Sanchez from the department as well. And then the co-moderator for today's event, Zach Richardson from our bar executive office, assisting Ms. Fisher with all of the support and that it goes into setting up and making this meeting run smoothly. So thank you all for your valuable assistance today. We have a presentation that's first going to be given to everyone by Matthew Gibson, who is newly appointed as a program manager 2. He's been appointed and promoted to this position. It's a 2-year assignment to essentially serve the executive office here at the Bureau of Automotive Repair and my office in particular in the implementation efforts of a very significant piece of reform legislation that was signed into law by Governor Newsom last year, AB 471. It was a bill that was introduced by Assembly Member Evan Lowe when he was chair of the Assembly Business and Professions Committee, and it has some very significant reforms that are provided for in this bill. One of the provisions in the bill calls for the Bureau to establish an informal appeal process through a citation program that the Bureau had been discussing and has been discussing and workshopping for the last couple of years with interested parties. And here to give us some more information on how that bill is going to be incorporated in our proposed regulations is Matthew Gibson, who is, as I said, the point person on all things relating to that legislation, AB 471. So Matthew, welcome. Thank you for, earlier today, the presentation you gave on the implementation strategies behind the bill and all of the various provisions contained in that bill. Today's workshop is just going to be dedicated to one of the provisions in that bill. So I wanted you to be able to share with everyone our latest attempt to draft regulatory language that captures our interest in expanding our citation program to beyond violations of the smog check program and beyond violations regarding unlicensed activity. Those are the only two areas that we issue citations right now. And we are looking at expanding that authority to violations of the Automotive Repair Act and violations specifically by automotive repair dealers that are registered by the Bureau of Automotive Repair. So Matthew, welcome back to this afternoon session, and thank you for the presentation you're about to give.
Thanks, Pat. And as Pat said, I'm Matthew Gibson. I'm a program manager in the Bureau's executive office, and this is our third workshop to discuss the proposed extension of BAR's citation program to automotive repair dealer violations by registered automotive repair dealers. I presented on BAR's interest in creating an automotive repair dealer citation program and a rationale for doing so at the October 2020 Bureau Advisory Group meeting. We held our first workshop on the proposed ARD citation program after the Bureau Advisory Group meeting in April of 2021, and we held the second workshop after the Bureau Advisory Group meeting the following July. Those PowerPoint presentations are posted on the BAR's website, on BAR's website, and those meetings are on YouTube. We felt this third workshop was necessary to cover not only the changes made as a result of the first two workshops, but also additions made as a result of Assembly Bill 471's passage and other changes made after discussions with DCA Legal. Since the proposed regulation text has grown to 10 pages, I have put this PowerPoint together, which contains 6 slides to cover the items contained within the revised text. There is some overlap between this presentation and the one I did this morning at the Bureau Advisory Group meeting. I should say that obviously this is a rough draft which is intended to solicit input, and we do anticipate that there will be changes based upon our discussion today, as well as changes resulting from internal staff discussions at DCA and BAR. So the proposed regulatory text will create Article 11.3 in the California Code of Regulations for administrative citations and fines and orders of abatement to automotive repair dealers. Earlier versions of this proposed regulation text included citable violations. Those sections have since been removed. Instead, I will be covering the violations which we are intending to issue citations for. I'll be covering fine amounts, the appeal process, and the changes made to the appeal process as a result of Assembly Bill 471, and also the AB 471 provision for non-disclosure of an ARD citation. So these are the violations which we are intending to issue citations for. The first one is negligence, but having said that, negligence is in the current draft of the proposed regulation text, but it's going to be removed. Citations issued for an extreme departure from an ordinary standard of conduct will instead be covered under Business and Professions Code Section 9847A5 for conduct constituting gross negligence. We have inaccurate invoice specific to labor that was not performed or parts that were not supplied as invoiced and paid, but where investigation finds a bona fide error. Maintenance of records specific to providing records requested in response to a specific consumer complaint. We have the accepted trade standards, and I mean all of the accepted trade standards, ball joints, engine changes, automatic transmission, air conditioning, and the more specific auto body trade standards such as auto body and frame repairs and inflatable restraint systems, as well as the equipment requirements. So under 3351.5, the equipment requirements for auto body repair facilities, and 3351.6, the equipment requirements for air conditioning repairs. So on fine amounts, all of our citations shall include an order of abatement, and the fine amounts will not exceed $5,000 even if the citation lists multiple violations. The fine amounts will be based upon 9 factors in aggravation and mitigation. I know it says 7, but there was changes since this got posted. So the answer is 9. And on the appeal process, here are some of the changes made to the proposed ARD citation program because of Assembly Bill 471. So ARDs may contest a citation within 30 days of issuance, but appeals will go through an informal citation review process prior to a formal appeal. Those citation review conferences will be heard by a 3-member panel, and the panel will consist of a representative from BAR, industry, and the public. And as a result of Assembly Bill 471, BAR will offer remedial training to prevent public disclosure of a citation under the following conditions. Only for violations that BAR deems to be minor in nature. Training must be successfully completed by someone who directly or indirectly controls or conducts business at the automotive repair dealer. And it'll only be available once every 18 months. And remedial training looks like it'll be an 8-hour class provided by a BAR certified instructor or provider on compliance with BAR's laws and regulations. The remedial training course content and provider certification process will be covered in another proposed regulation package, which we hope to workshop in early March. So that is the presentation, and I am going to switch over to the regulation text. I wasn't going to read it though. I thought we would just start asking you if anybody had questions.
But this time, I appreciate the presentation you gave, Matt, and I think we can start opening it up for questions and comments. I know there's been some changes since our last workshop, some of which are based on comments we got at the workshop, but also ongoing discussions with staff at the Department of Consumer Affairs, our own Bureau of Automotive Repair subject matter experts, and regulation coordinators here, my own office. So there are changes that have been made since that last, what was the last workshop? Back in,
It was July of 2021.
yeah, it was, we had two workshops last year, April 22nd and July 15th of last year. So there have been some changes made that might look different than what we last saw, but that's to be expected with works of progress like this, and certainly, obviously, the need to incorporate the provisions of AB 471. So let's open it up for comments or questions, suggestions. We want to hopefully capture all of the concerns and questions and comments today and finalize this package to be able to complete an internal review process that we have to do through our legal and budget and our own agency, as well as before it gets submitted to the Office of Administrative Law. And then there's a more formal public comment process that lasts at least 45 days, minimum of 45 days, I should say. So more work to be done still, but I'm hoping that this might be the last workshop on this package, but possibly not, depending on the kinds of comments we get today and whether any additional or further changes are made. Let's start with, I see some bar advisory group members who are in the list of attendees with hands raised. I'll just go in the order I saw them. Jack Molodonov, who represents the California, Auto Body Association.
And Jack, I've sent you a request to unmute your microphone. You can click that and then you'll be ready. Now you're unmuted.
Good afternoon. Can you hear me?
Yep.
Oh, thank you. Thanks, Matt. Thanks, Pat. I do have some comments and questions, and maybe just going to your presentation would be easier.
Okay.
I don't, yeah, just like page, if I remember here, page 2. The next one, yeah, it's the citable violations. So just going back to our previous workshops, I know inaccurate invoice was in the previous draft. I think that was section 3356.1, which defined inaccurate invoice. And I know you've made reference here to BMP code section 9884.8, which lists, you know, what an invoice needs to have, the requirements, but nothing in there that actually defines an accurate invoice. And I thought there was consensus on the definition of an accurate invoice, and just not sure. I didn't see it in the actual text. Just wanted to ask, I thought it was, you know, like I said, consensus, good idea. What happened there? Why is it not there? Yeah.
So 3356.1 inaccurate invoices was in the draft that we workshopped back in April, but it wouldn't have been in the one that we workshopped in July. And I'm saying it like a question because I'm not exactly sure that's 100% accurate. All I know is that prior to Assembly Bill 471, you know, getting chaptered, we had already shifted away from using a regulation to just using part of Business and Professions Code section 984.8 as the citable section related to inaccurate invoices. And so the reason it doesn't show up now is because where it was listed in the version of the text before the one that got posted today, it was in a section of citable violations that's not there anymore. So we had moved away from it, but are you thinking there was a benefit to having that in there?
Yeah, I do. I think, as I recall in the workshops, we talked about the instances where a shop may have charged for a part not, put on the vehicle. There was no intent there, and this was a inappropriate, probably measured for maybe a citation rather than an attorney general type of action or investigation. So, yeah, I thought because the regulations don't actually define what an inaccurate invoice is.
You're right. Right now, there is no regulation that says inaccurate invoice. That's true.
Yeah, and I'm just wondering why. I guess is there any? Yeah, I think it should go back in, and I don't know if there was some sort of objection to it. Like I said, I just remember consensus on the language, and I'm just trying to figure out. And I thank you for the explanation, but I do think it should go back in unless there's some kind of objection that I'm missing.
If there must have been, well, all I'll say is this: in amongst the length of time that we've been working on this and workshopping it, there must have been an explanation for why we did it. I don't know if I exactly remember why, but at this point, since we don't have, well, maybe it would be worth including, and I guess it's something that.
Okay.
I appreciate the comment.
Yeah, that's my comment. I think it should go back in. And I know that on this page you talk about the citable violations, and that's your intent here. The maintenance of records, accepted trace standards, equipment requirements. But I did notice in the actual text itself, in the prior version, those were actually listed out. Now they're not listed out. Just wanted to get clarification on, that particular change in the text. And the meaning of, why those are not laid out like they were before.
Matt, I
You
try
want
to.
to go?
I'll try to tackle this.
Okay.
I think with the ongoing discussions that we've had internally with the department and our own bureau, we have determined in reviewing the Automotive Repair Act that the bureau does not have authority to limit the jurisdiction that has been provided by the legislature in the enactment of the Automotive Repair Act in 1971. And nor do we have the authority to expand on that authority. We've, in a couple of regulation packages that I won't get into today that we've been discussing, we have determined that sufficient statutory authority does not exist to do some of the regulatory changes that we've been discussing with our bar advisory group, maybe even workshopping in the case of at least one of the packages. And that is just as a result of our ongoing understanding and further discussions with our bureau staff and our department, which includes, as I've alluded to, our legal counsel, our budget staff, and other key internal stakeholders at the department. In response to this question, Jack, we did think that we would, based on feedback from and work done by an internal work group that was initially established to look at the sections that we would be citing and interested in citing for, recognizing, of course, that we get probably upwards of 15,000 or more complaints a year where there could be a violation, perhaps in each and every consumer complaint that is mediated. Is it BAR's intent to issue a citation in each and every one of those instances? By no means. We'd never be able to get any other work done here at the Bureau, and certainly would be missing the opportunity to address some very much more egregious violations, perhaps, that go beyond the need to cite an automotive repair dealer for some predatory practices that relate to fraudulent repairs and things like that. So it was our intent all along, and it's still our intent, and was communicated to the bar advisory group and to our stakeholders through the prior workshops to limit it to a few sections of the Automotive Repair Act. However, having said that, we, cannot regulate that. We cannot put that in regulation. We can use it or exercise it through our administrative discretion to look at things that we'll cite for versus things we'll educate the automotive repair dealer on, or even things that we decide to do with a more kind of a stepped up enforcement response, such as a revocation action. And that's what I want to point to is the section 9882 of the Business and Professions Code, wherein it says the director may adopt and enforce those rules and regulations that he or she determines are reasonably necessary to carry out the purposes of this chapter, and declaring the policy of the Bureau, including a system for the issuance of citations for violations of this chapter. I put emphasis on that word, chapter. And it's as specified, it goes on to say, as specified in section 125.9 of the Business and Professions Code, which talks about a citation being in writing and it being clear about what the violation is, and appeal rights of the person who's been cited, and so on and so forth. Well, it does say violations of this chapter. That's what the legislature has said, and that is true with, to my knowledge, every board and bureau under the Department of Consumer Affairs. They have authority to cite for a violation of their enabling statute. And in our case, the enabling statute is the Automotive Repair Act of 1971 that took effect in 1972. It is not BAR's. BAR does not have the authority to limit in regulation the broad authority that the legislature has provided. We do have discretionary authority, much like all the other boards and bureaus who have citation authority, to decide those violations that we decide to address with just a conversation, education, or something a little more impactful, such as a citation, or even beyond that, an accusation to revoke someone's license. Would we do that with an estimate and authorization violation that there's no proven practice of misbehavior and doesn't look like some intent to deceive consumers? No. We'd probably address that with some kind of sit-down educational type of discussion. At some point, potentially, it could rise to the level of a citation, but it's, again, that's where BAR's discretion comes into play. I also will say citations aren't issued, so for those worried about the Bureau having some interest to issue citations and just running them up, which I've already shared with you, there is no such interest. There is no desire. We don't have the bandwidth to issue citations of that magnitude and that volume. We do have checks and balances built into the Bureau of Automotive Repair to ensure that citations are consistent with policies set by the Bureau Chief, myself, and executive leadership here at the Bureau. All citations are reviewed by a central office under the management of Bill Thomas, who runs the Enforcement Operations Branch, a centralized office, if you will, that all citations go through, with the exception of, so when a citation isn't issued by anyone in the field operations in the smog check program currently, and wouldn't be under this program. The only exception is with respect to unlicensed or unregistered activity, wherein the field representative who's identified that there's unregistered or unlicensed activity is going on has the authority to issue a citation to say, stop operating as an automotive repair dealer, please get registered, and they'll issue a citation. In most instances, if a citation with no monetary fine, because the interest is to promote registration and licensing, and we don't want to have a deterrent to that effect. The registration itself is $200. That's, I guess that would circumvent, or not circumvent, but replace the fine amount. I mean, you're trying to get this entity registered or licensed. And then the citation would just be for an order of abatement. But that is the only exception to say knock off the behavior and get registered. And that is the only time that a citation is and will continue to be issued by someone out in the field. But that checks and balances exists for smog check citations and will for Automotive Repair Act violations other than for unlicensed activity.
Okay.
I hope that is responsive to the question that was raised by Mr. Maladano.
Yeah, thanks, Pat. I appreciate that. It just seems like we're opening this thing up, and I appreciate your comments. I think if we go to the next page, page 4.
Before we do,
Okay.
Jack, I just had a comment. Maybe I noticed that it says negligence. We've also determined that BAR does not have the ability to issue a citation for negligence. Our statute speaks to gross negligence. The only time negligence is referred to in our statute, the Automotive Repair Act, is with respect to advertising, I believe. Matt, is that correct?
And as I was going through the presentation, I mentioned we're taking it out. It's being removed.
Oh, okay. I may have missed that, and I apologize. So it now should read gross negligence as opposed to negligence.
Yes.
Okay. Sorry, Jack. Sorry to cut you off there. I just wanted to add that to that comment to that page.
Yeah, now that sort of the direction's going a little differently in terms of opening it up, I know the intention and what we're saying in terms of the regulations. I think it's probably more imperative now that there are some what I would call guardrails or some clarity for issuance, or at least recommendation of issuance of a citation, because under current law, as you mentioned, Pat, I mean, you have education, or there's no in between, no citation, there's attorney general action. So right now under current law, a representative can provide a station report or an educational type situation, an office or a proactive conference. With this regulation, then there's going to be discretion of issuing a citation. So you've got a lot of subjectivity there, and I think it would be, just my opinion, it would be more important to at least have some guidelines, some clarity for ARDs, for the BR representatives, for everyone out there. And I think the section that deals with the factors of aggravation and mitigation, I think that area could be worked on together where it can provide that clarity. For example, maybe adding in there if a ARD can show some evidence, showing some evidence of the violation, it was a bona fide mistake. In other words, so when the BR says, hey, this may have been a mistake, maybe we don't need to issue a citation or recommend a citation here. Maybe in this instance, we can do education. Or if a ARD took preventative measures, like attended a BAR compliant training class, regulation with regard to laws and regulation, maybe that's something that could be considered in the determination whether not only to how much the fine amount should be, but whether to issue the citation in the first place. So I guess, Matt, what I'm saying is that maybe that those areas of mitigation can be worked upon, or at least we can add certain things to provide additional clarity for representatives out there and the industry. I think that may be what we call maybe guardrails out there. That's the suggestion.
I think that's a good comment, and something we're very much open to. As you see, there's 7, and Matt has corrected to say that there's 9 factors in aggravation, which could actually um, lend itself to a steeper penalty if you have maybe higher violations that have where we've informed the automotive repair dealer. So there's factors in aggravation, but there's also factors in mitigation that I think you're alluding to expanding. So that list could potentially be more than just the 9 we're talking about. And I think we're open to that. I certainly understand your concerns with taking out or removing the citations that we intend to issue citations for. So those, if you will, those guardrails or safety mechanisms or whatever you want to call them to ensure that the bar doesn't go extremely crazy with this new or proposed authority. I think we'd like to and be open to and entertain some additional work in this area. So if you have specific language, I think we'd like to see that. We'll also take a look at it as well internally, just to try and capture these comments. And obviously, with a caveat, we do have to run it through our review team at DCA and BAR. I will say one other mechanism that's provided to give you that, hopefully satisfy some of the concerns you're raising, Jack, is AB 471 built in that informal appeal process with a 3-member panel. So if there was something that just was completely somehow a citation slipped through despite these internal checks and balances that I've referenced, and somehow I was asleep at the wheel for some reason on something that and it slipped through the cracks. I don't know. Just think of something. You've got that ability to have this 3-member panel look at a citation and see, was this warranted for this act? And I think was a nice little safety valve, if you will, for that Assemblymember Lowe built in to make sure that there are those guardrails, safety mechanisms to make sure that we don't have a government agency that kind of is running wild out there.
No, I agree. I appreciate those comments. My final comment, Matt, is on page 6. I just in terms of the non-disclosures for allowing BAR to offer the remedial training. I know in there it says only for violation the bar deems to be minor in nature. I know 471 talks about record keeping, documentation, or what BAR deems minor in nature. I would, and I looked at the language, and I know in the language there are limitations to which sections, and I think you may want to revisit that and maybe just say the areas where you can't get you're prevented from actually going to remedial training, which were citation, things dealing with fraud. You can't go to remedial training for fraud, or I'm sure gross negligence, but maybe take a look at that, because we're limiting certain areas in the text you have, and I don't think that's accurate, because there could be a documentation issue dealing with an estimate or an invoice or an authorization, right? So it's very broad, and so to limit it, I see some inconsistencies. You limit that, but then you kind of open up when you can issue a citation, but you can only limit, you know what I'm saying? I think it should say consistent with the statute of AB 471. That's my point there.
Okay, I understand. It's a good comment. Are you sure you didn't want me to pull the text up, Jack? I mean, we could look at it.
I just was making the comments.
Right.
And that's fine. I didn't know. I just wanted to, just summarize my comments for you. I didn't want to take too much time, but I think those were the areas where I wanted to make sure that I brought to your attention that we can kind of look at and improve for everyone out there. So thank you for your time, and I appreciate it. Thank you.
Thank you.
Thank you, Jack. Let's go to our next hand that's raised. I see down in order here. It's Johan Gallo with the California Automotive Business Coalition.
And
Hello?
oh, there you go.
A follow-up to the items that have been discussed on the citable violations having to deal with inaccurate invoices is really a follow-up to our conversation this morning. And I realize that it's very specific, and what they're saying is considered an inaccurate invoice, but it goes back to the software issues that we're not only having with major retailers. I don't care if it's Firestone or any of the other large chains that are out there that operate in California, but our independent dealers and repair shops are having similar issues with software vendors that they buy their programs through, that they are not doing the proper job in providing the job descriptions. And I know that we've had this conversation a couple of times before, but it especially now when we're dealing with the potential of seeing citations issued for an inaccurate invoice. And I know that we've been in a position before discussing it with Pat and others that, you know, we're not asking the BAR to take on licensing software for point of sales terminals for California. But I do think at this point we have to consider what we could possibly do, not only through all the different associations, but also working with BAR and DCA on some type of requirement or some type of regulation that if you're going to be providing software, it's got to comply with total disclosure. It's got to provide accurate description. I got in a discussion just the other day that, you know, you can't use reman, you can't use R&R, you have to spell it out. And if you have to go back to your software vendor to get them to do that, then please do so. And so those are really the issues that are concern to our members when we're looking at now citable violations and inaccurate invoices.
Okay.
Thank you, John, for the comment on that. There are additional comments you had?
That was the main one.
Very good. Yeah, I know that's a really big issue, I know, for the Bureau and the industry, and that we don't regulate the software providers that build these point of sale systems, and they're trying to do oftentimes a one size fits all for auto repair facilities throughout the country, if not beyond this country. Obviously there's other languages and things like that you have to deal with, but certainly within this country, trying to build a one size fits all when the Bureau of Automotive Repair is unlike any other, and our law is unlike any other state, doesn't necessarily serve you. It doesn't serve consumers. It doesn't serve any of us well. So it's a real challenge. Obviously we, you know, because our authority is within the Automotive Repair Act, and we license, license and regulate automotive repair dealers, we can only hold ARDs responsible for the compliance with the law, not these service providers. So if there is something that's not compliant with the Automotive Repair Act, the expectation is, as you've pointed out, and we've made this clear in presentations, is that the automotive repair dealer correct the point of sale system, you know, with a pin. You know, we always want to just rely on the the software to do everything for us, but in the event that something is not compliant with the Automotive Repair Act and our laws and regulations, we do expect the automotive repair dealer to make those corrections with a pen or something that overrides that software system.
Yeah, I appreciate your comments. Having worked with California car dealers and also worked with the independents as well as the mass merchandisers, the problem's pretty much relevant across the board. And, so we have to
Yeah.
find a different solution for it. But very point well taken as far as just making comments on the invoice to override whatever the software was deficient in. Thanks.
Good comment, though. Thank you very much for pointing it out. The challenges that are faced by all of us in having to respond to some of the limitations with software that is trying to be a one size fits all and not necessarily created for California. Let's go to our next hand raised, Anthony Bento with the California New Car Dealers Association.
And Anthony, I've sent you a request to unmute your microphone. You're unmuted.
Can you hear me?
Yep.
Fantastic. Thank you, Pat. Thank you, Matt, for your and staff for your tireless work on this. I know that we've had many workshops on this, and the work has certainly not gone unnoticed. So very much appreciate that. I have a quick question or point of clarification on negligence. You mentioned that based on an internal review, BAR determined it does not have the legal authority to adopt as a citable violation negligence generally, but you do have the authority to adopt a regulation on gross negligence. Is it the intent of BAR to adopt such a regulation which would replace the regulation on negligence, or are you simply contemplating a deletion of the regulation on negligence? And if you are contemplating a new regulation, would we be able to see the draft language for gross negligence prior to or in a future workshop, perhaps?
What I'll say is that we were going to take out, so we were going to create a new California Code of Regulations, which is actually on the screen right now, 3351.7. We do, oddly enough, have authority to define negligence, but we don't have authority to say you can't perform negligent repair. Under our 99847 sections, again, specifically to A5, we have conduct constituting gross negligence as a cause of discipline. And since under 9882, we can issue a citation for any violation of the chapter, that's how we're going to fill the hole left by the removal of negligence. So no, we weren't going to generate another regulation.
Great,
Does
thank you.
that answer the question, Anthony?
Yes, I was muted and I couldn't unmute myself. My apologies. I'm not sure how the system works for this workshop, but the that does make sense. So you're simply contemplating a deletion of the proposed regulation for negligence, and then that will be the only change to the proposed regulations themselves.
The ones that were posted, yeah. I mean, there's some other minor issues related to capitalization of the chief. I mean, there's some other stuff that didn't get cleaned up exactly before it got posted. But yeah.
I don't think anyone, I mean, I'm certainly not going to lose any sleep over technical changes, or things like that. I just wanted to make sure that if there was going to be a new introduction of a substantive requirement or definition, that there would be an opportunity to comment on it. But that doesn't sound like that will be the case.
Okay.
Great. Thank you so much.
Thank you.
Let's go to the next hand that I see raised. Hal Wynn. Hal, welcome. Please, I can't remember the name of the organization you're currently working with, but I I know you've been doing a lot of work educating and training automotive repair facilities out there after a stint previously with the California New Car Dealers Association. But please introduce yourself and the organization you're representing today, and look forward to your comments.
Sure. Thank you, Matthew. Thank you, Pat. Again, my name is Hal Wynn. I'm General Counsel for Comply Auto. My experience stems from working with the California Car Dealers Association and Auto Advisor Services directly with ARDs in their training. I wanted to piggyback off of Jack's comments earlier about training in the Automotive Repair Act by a bar certified instructor as a mitigating factor in assessing a fine or a penalty. I would argue that one of the ultimate goals of these regulations is to clean up the industry, right, and penalize bad actors, but not unfairly penalize those who are just trying their best and just actually having to overlook something or having something fall through the cracks. So I think training in the Automotive Repair Act as a mitigating factor, or even as a safe harbor to a certain extent, would shine a brighter light on those violations that are under review. Which ones were done on accident or an oversight, as opposed to those being, done more willfully or done in bad faith.
So if you're the comment I think you're piggybacking on was the one related to it adding an additional factor within our aggravation mitigation, the 9
Precisely.
factors, is that what you're referring to?
Yep, precisely.
Okay, I just want to make sure I understood. Okay.
Thank you, guys.
Oh,
Thank you.
that's it. Okay, thank you, Hal. Good to see you or hear from you.
Likewise.
Do we have, moderator, any other hands raised?
We do have a question from Nikki. And Nikki, I'm going to send you a request to unmute your microphone so that you can ask your question.
Gotta leave in a minute, but I just wanted to ask a question about the 3-member panel. How's that gonna work? Is it gonna be one panel for the whole state? Or is it gonna be a panel assigned for every appeal process? And specifically, what are gonna be the qualifications for somebody who's an industry or a public member? Or is that not been determined yet?
I think we've given consideration to how to run the panel, and we've come up with different theories, but I don't think we've settled on anything just yet. We would probably have these review conferences held virtually versus having them done in person, so there wouldn't be like a panel in Northern California, one in Southern California, or even some number. They're all going to be probably in Teams or Zoom or WebEx, and so the consideration about the people we want to put on the panel, I don't know that we've had conversations about that. I know, so for example, I think we're going to need to have a number of industry folks and a number of consumer folks. I know where all the bar people are at, so I know we can get those people, I know, at any time. But we haven't really made a decision on how to come up with those people yet.
Matt, I think we've had some discussions about having a bench and,
Yes.
and not necessarily having to rely on one panel, but so we could have, a few bar designees, perhaps a few industry designees. There also is a provision if I'm not mistaken, there's a provision in there, is it in this latest draft, where a panel member is expected to recuse themselves if they have a conflict of interest. So perhaps there might be someone that's close to the industry representative that may be called upon to hear and sit in on an informal appeal. And this might be someone that the panel member that's called upon knows fairly well, related to, or something on that order. And we would expect that the panel member would take themselves out of hearing or participating in that informal review, and then we'd call on someone else who does not, and who would step up and
So what
fulfill that obligation.
So what I'm wondering is, so like the industry person that would be on the panel should know, if it's an auto body thing, should they know something about auto body? Same with the public members. Should they be aware of the automotive industry, or is it just going to be a random?
Well, the public's a little harder there. Yeah, I don't know what the expectations there are, but I do think you make a good point, valid point, with respect to the industry representative. You know, if you've got a collision repair, auto body repair, um, you probably want someone who knows something about that business as opposed to, more mechanical or some service portion of the industry.
Okay, I'm just trying to figure out how this is gonna work. Thank you.
Yeah, it's still being processed by us. I mean, certainly some suggestions. I don't know if that's part of the regulatory process or just more of our administrative discretion on how to operate the panel in that regard. But certainly your thoughts on it, regardless whether it's administrative or regulatory text that we need to draft. Your thoughts on it are welcome.
Okay, thank you.
And that was Nikki Ayers from the Independent Automotive Professionals Association, IAPA. Thank you, Nikki.
Thank you.
And I do not see any other requests for comment. If someone in attendance wishes to make a comment, you can either click on the Q&A box and type comment in the text box there and hit send, or you can raise your hand. Or if you are a call-in user, you can hit *3 to raise your hand. And I don't see any other requests for comment.
Well, then I appreciate everybody coming to go through our third workshop on the auto body citation program regulations.
At this time, Matt, not to put you on the spot, but do you think another workshop is, I mean, I think we're trying to finish this product and move on to some other additionally critical components or provisions within that bill, AB 471. Has there been anything that you see is worthy of, I mean, I think we'll add some additional mitigating factors, perhaps. I think like I've said, we're very open to that. Obviously, the devil's in the details, but I don't know if anyone would object to us moving ahead with this or one last crack at this. I'm trying to kind of finish this process off, but realizing, of course, there are still opportunities to comment on this. There is the formal process once the regulations, should they get internally approved through our processes with our department and our agency, they get filed with the Office of Administrative Law, like all regulations, and then they get publicly noticed and an opportunity to be heard on the record, if you will, through the formal public comment process that's at a minimum 45 days. And sometimes is extended because of some redrafting of the proposed regulation that based on comments that we received in that formal public comment process. So I'm hopeful, but I don't want to cut off the need for another workshop. But I feel like we're very close to the finish line on this one to move ahead. But I'll see what we get in terms of our next draft of this. If there's extremely significant changes, maybe we'll need to workshop it again, but I'm reserving the option to maybe cut off this and just move forward with the moving this package forward to the Office of Administrative Law and allow people to comment through that formal process as the one last time to weigh in on it. Okay. All right. Any other final thoughts before we adjourn? It does say we're scheduled to 3:30 or until the close of business, which gives us the flexibility to end a little early, give you back some time in your day to do some other things. Any final questions, thoughts, considerations before we adjourn? Okay, seeing none, I want to thank our moderator, Ann Fisher from the Department of Consumer Affairs, our co-moderator, Zach Richardson, here in the executive office at the Bureau of Automotive Repair, and then Mike Sanchez, who is responsible for the webcasting of this workshop, meaning that it'll be posted to our website as early as next week. And then lastly, I want to thank you to Matt Gibson for the presentation and all his work on this regulation package and all of the other regulation packages involving AB 471. There's going to be a lot of discussions forthcoming, and they won't be necessarily tied to a bar advisory group meeting. There'll be more frequent discussions because these packages, there are some deadlines for getting these packages adopted. So we want to move, we want to be very nimble and move very swiftly with getting feedback from our internal and our external stakeholders. So be on the lookout for additional postings about other workshops that are going to occur in advance of our next bar advisory group meeting. Thank you all for your attendance today, and thank you for the excellent comments and feedback on this latest draft of the package, the regulations dealing with proposed expansion of our citation program to violations of the Automotive Repair Act by automotive repair dealers. Look forward to the continuing dialogue on this package. We're adjourned. Thank you very much.